Mainstreet Capital Holdings versus DeBartolo Development. You can get to the podium if you want to reserve rebuttal time. For all the appellants, just let me know and I'll give you a heads up.
Good morning, Your Honors, and may it please the Court. I'm Thomas Burns, and along with my co-counsel, Mike Beltran, we represent Mainstreet. I'd like to reserve 5 minutes for rebuttal, please. This is a non-final appeal about two issues. First is the enforceability of a contract clause for AAA non-binding arbitration, and secondly, who pays for it. My colleague and I have fundamental disagreements about both issues, and we need your assistance to resolve them. In a nutshell, as I understand my colleague's argument, he contends that trial courts must enforce contractual clauses regardless of their statutory or procedural authority to do so. And in contrast, we contend that statutes and procedural rules matter very much. So let's get into the details. First is the enforceability question.
Let me ask you this. There was a motion to dismiss or stay. I mean, could this provision have been viewed as a condition precedent to filing the lawsuit under the contract? Said you shall not litigate, shall not engage in litigation until you have first given the person you're going to sue the opportunity for arbitration.
The case certainly wasn't litigated that way in the trial court. I'm not sure. It's sort of hard to say because that issue just wasn't raised and preserved. So I would think that if you were to agree with me and remand, perhaps that.
Because this isn't an arbitration, the typical arbitration clause that you see in a contract that says, any and all disputes will be subject.
Right.
It was not that. It was, you have to offer this opportunity before you sue clause.
Right. Well, there are other cases that involve clauses that they're not exactly like ours, but are somewhat similar, like the advanced body care case. That's an 11th Circuit decision. It also, you could read that clause as being a condition precedent to suit, but that's not how the 11th Circuit handled the appeal. They just said,
well, that's because it was brought under the issue was raised there as it was here as a FAA motion to compel, basically.
Right.
I'm not entirely certain the practicalities of this or any of our business, but I mean, this arbitration provision does have the classic language of conditions precedent, and one wonders kind of
right, and
what your client hopes.
Perhaps the case could be litigated that way on remand, but
there hasn't been an answer in affirmative defenses in this case yet, right?
Right. We don't know yet.
Right. So it goes back. Say we send it back, they file an answer that says, no, we deny that you have satisfied the conditions precedent, and there's the affirmative. There's the answer specifically. You haven't given us this opportunity, and you could go through with this again.
It could happen.
Yeah.
I'm not sure how that would play out in the trial court. All I know now is that it's not been litigated that way, and it's not been briefed. The appeal has not been briefed in that way. So I would, if I were you, I'd hesitate to go into that area. I would just decide what's before you.
Well, can I ask just kind of one more threshold question, which is to what extent does footnote 1 of Avatar Properties box us in at all here? That is the part of our decision in that case that basically said we had direct appeal jurisdiction over an order compelling non-binding arbitration under the provision of the appellate rules that says we have jurisdiction over non-final orders determining an entitlement to arbitration. That at least implies that we looked at the rule-based term arbitration and decided that non-binding arbitration was included.
I don't think that point goes to the merits of the decision that was in that case. It went more to just, do we have jurisdiction or not?
Right, and it interprets the same term we're being asked to interpret in
right.
the FAA and the FAC.
My response would be that appellate courts are courts of review and not first view. And the way that appeal was briefed by the appellant was, you didn't use arbitration in your clause, so therefore it's unenforceable, and also you didn't attach this one document to it. And so the second DCA quite properly said, okay, that's what's before us. You're incorrect about the labels because that doesn't control, and you're also incorrect about the attachment because there's like a zillion cases that say if something is incorporated by reference, it's deemed incorporated. So tough luck, appellant. And then you have, obviously, the concurrence by Judge Altenburn, who's
Right,
addressing some...
but we said in the footnote, we conclude that we have jurisdiction because this is an appeal of a non-final order determining the entitlement of a party to arbitration.
Yes, and I believe that's, a correct statement of law. You do have jurisdiction.
You can't infer beyond that because then you'd be caught in this loop. You've ordered arbitration, but it's not an arbitration clause, but you can't get it reviewed because it's not an arbitration clause. You can't.
Right, and
you would be in this.
like a persuasive authority you might look to about that question is, again, the advanced body care case where Judge Kravich said for the 11th Circuit, look, this is a non-frivolous motion that was filed. Even though we disagree with you on the merits, we conclude that we have jurisdiction. So I wouldn't conflate the merits question and the jurisdictional question. I think they're quite separate, if that responds to your question.
You have the same word mean in different things, different places. I'm not necessarily uncomfortable with that, but that is an implication.
I think that's sort of a natural reading of the rule because you want to be able to take these things up on appeal, and then as far as the merits, you might have a narrower construction because the word arbitration, it's essentially common law that's been developed under the FAA and the RFAC.
What do you think the odds are that if we were to agree with you and reverse it, that Judge Stevens would send you to arbitration anyway under the rules of civil procedure?
I think that's highly unlikely. He during the various hearings...
He said he thought that was a ridiculous rule, although on the other hand, he thinks he's enforcing a contract.
Precisely.
And he might disagree with our disagreement.
Precisely.
He may give them the benefit of the bargain.
That's, I think, what he was doing. I think the judge felt bound by the contract language and didn't do the analysis. Basically, he got the cart before the horse. He looked at the contract and just said, I'm enforcing this, rather than saying, well, what procedural or statutory authority do I have to enforce this clause? And so he did the analysis backwards and didn't think...
Let me ask this question, though. Is there any reason he could not say, under the rule, listen, clearly the contract says what it says. We're going to be litigating about this now, or we're going to be litigating about it later. We might as well get it out of the way, go forth and do what the contract says you need to do. I mean, is there a legal or analytical reason why he couldn't do that?
Yes.
Okay, let's
hear
it.
That's a good start, right? So the first response is, and I think I stated this before, is obviously he didn't do that. The second part is he would need to make specific findings about it actually being of benefit to the litigants. And our position is, this is, and the trial court apparently agreed with us, this is an incredibly wasteful procedure. It's not going to relieve court congestion. It's not going to reduce anything. It's just an additional layer of litigation that we have to go through before we actually litigate this case in court.
But the benefit might have been to keep it confidential, basically, not on the public record.
But we're going to be in court anyways. There's no way that this award can be confirmed by the trial court because the clause of the contract says that.
Right. The benefit might also be the same foresight that Judge Northcutt has exercised, which is we're going to be...
I want you to write this down. He said on October 16th, he accused me of having foresight.
Was a hat tip.
Yeah.
That the parties are going, this is going to be a disputed issue in the case, and I can either resolve it now at the outset and, not have a bunch of litigation and just end up telling the parties they have to go back in terms of what I can see as a foregone conclusion now. Why wouldn't that be a sufficient benefit to the parties to justify compelling arbitration under the rule?
I don't see how it advances the resolution of the litigation, and that's the ultimate purpose of arbitration, and that's explained in the advanced body care case. The point is to move this case forward, and going through this arbitration procedure, a AAA non-binding arbitration procedure that's been described in the contract, it's just not going to advance anything. I mean, we could go to this arbitration...
of that argument, though, that non-binding arbitration should never be ordered then? I mean, right, one could say that about non-binding arbitration in any case, right?
Well, there's a difference because if it's done pursuant to the rule 1.800, 1.820, and the statute, which is section 44.1035, if it's done pursuant to that, you have the findings that it's going to be beneficial to the clients, but it also has different non-waivable provisions of how the arbitration works, and that kind of award could be confirmable if a motion for trial de novo is not filed. So it's just a totally different animal than the contract clause that we have here. And because of that, the judge would have to make these findings that the arbitration would advance the resolution of litigation. And I don't believe, first, the trial court certainly did not make that finding, and I don't think the trial court could make that finding. But I don't know that that's really an issue that you have to resolve here, because the court didn't rule on that basis. In fact, it's had quite the opposite. I'm not ruling on that basis. I'm ruling exclusively based on the contract.
If you talk about the fee and cost provision,
I'm sorry?
the cost portion of the order.
Of course.
You have 10 minutes, and so I want to.
Yeah, let's get that.
Use your time.
Yeah, I have a few more points about the FAA and RFAC, but let's talk about the payment. So I think the most obvious outcome that you should reach here is that we should split the fees. That's what the AAA non-binding rules say. That's the default
And
rule.
that would arguably be what the contract then contemplated when it's
Yes.
specified AAA rules.
Right. And I think the trial judge was just looking at the wrong set of rules. Trial judge was looking at the binding arbitration rules, which are quite different. And there's a lot of case law that my colleague has cited saying, well, when you get into binding arbitration, the petitioner pays for the fees. We don't dispute that. We're saying this is asking for AAA non-binding arbitration, and the default rule there is you split the costs. Okay. We have an additional argument, as I'm sure you saw in the brief, that they should be the ones that pay the entire cost. The highlights that I'd like to point out are that this contract uses passive language. Only the respondent can elect non-binding AAA arbitration. We, as the petitioner, couldn't elect to do that. And for the reasons that we say in the brief, then we still contend they should pay the entire thing, because they're the ones who are electing to go forward with what we believe is
yay or nay, we're going to do it.
Yeah.
You have to give them the opportunity, and they say yay or nay. You can't say you have to go to arbitration.
Precisely, because we're the petitioner, and that's the way this clause is drafted.
Okay.
So getting back to the enforceability, what you need to do is understand what arbitration means within the meaning of the FAA and the RFAC. We're asking you to adopt the test of Advanced Body Care Solutions. That's an 11th Circuit case, but we think it's very well reasoned. And it essentially says that the bright line test for arbitration is whether there is a confirmable award. Specifically, the language is a meaningfully confirmed, modified, or vacated award. And we believe that the AAA non-binding arbitration that's been selected here cannot do that, because it specifically says it can't be made part of a judgment. Trial court can't enforce it, and it's just a meaningless thing that would take
And that's
place.
true under the AAA rules too, right? Like even if the contract didn't say what it said, you would be saying the same thing.
Exactly. It's the same, precisely.
Right.
Yeah, exactly. So we're specifically looking at paragraph 13.08, and then specifically AAA non-binding rule 1B, which I believe we cited in the brief. And Advanced Body Care gives a very colorful example, which is you can't agree for a binding coin flip. So here we don't even have a binding coin flip. It's like a non-binding coin flip, and that's not the kind of arbitration agreement that you can enforce under the FAA. But that's not
But that comes back to, my question about, the parties bargained for the party who's going to be sued to have an opportunity to resolve this off the public record. And these people are in a business where what's on the public record is pretty important to them. So how do they get the benefit of that bargain but for what Judge Stevens ordered here?
I think a better clause has to be written, one that is arbitration under the FAA or the RFAC. And I want to be clear about that. For us to prevail, we have to convince you that this is not arbitration under either the FAA or the RFAC, because if either one is deemed arbitration, yeah, then we're stuck and we have to go with this. So I think that's our point about why it's not arbitration under the FAA. We also think it's not arbitration under the RFAC, and the problem there is that both the AAA rules, non-binding rules, and the contract itself purport to very non-waivable provisions of non-binding arbitration. And specifically, we cited these in the brief, but specifically it's what I just mentioned, the trial court's jurisdiction to enter judgment, the possibility of judicial confirmation of the award, and judicial enforcement of the award. And both paragraph 13.08 and the AAA non-binding rules are quite clear that you can't do this. A court can't rubber stamp it. It's just, you have something that can't be meaningfully confirmed by the trial court, a trial court. That's our case, unless you have further questions.
No, you came in right in 15 minutes, even though Judge
I have an
Solorio
internal
and I were,
clock.
Peppering you, so you still have 5 minutes left for your
Great,
rebuttal.
thank you.
Thank you, Mr. Chairman.
Good morning. Bob Johnson here on behalf of the DeBartolo defendants. And our position, as counsel has indicated, is pretty clear. The parties are sophisticated businessmen. They were represented by counsel. They drafted this agreement, and we are simply seeking to enforce the terms of the agreement. And as I view Mainstreet's argument, is that they're essentially saying that this court should make a ruling, which has never been done in Florida, that non-binding arbitration is non-enforceable. And I don't think when the parties entered into this agreement, that's what they would have contemplated. And, we go back to our...
Let me ask you a question. Do you agree with Mr. Burns that a tether in the FAA or the RFAC is required in order to get a trial court to enforce the arbitration provision in the way that it did here? That is to say, a motion basically staying proceedings and compelling the parties to arbitrate.
I would disagree with that. I think that the agreement, the court, Judge Stevens said, I can enforce a provision of an agreement.
Well, it's a weird thing, right, that a trial court would be able to enforce contract provisions by way of just kind of freewheeling motion. I mean, ordinarily, but you would expect to see a pleading that asserted a failure of performance of the contract, say a defense of, non-occurrence of a condition precedent, or, a counterclaim for specific performance of a contract obligation. I mean, you just don't ordinarily see parties enforcing contract rights in this way.
Now, it may, and I apologize, I don't have my pleading, but we raised it in the form of a motion to dismiss.
It's a motion to dismiss or stay.
Or stay.
But this provision was raised in a motion to dismiss.
Correct. So we raised that in our motion to dismiss. Maybe it wasn't the most artful way for me to raise that,
Well,
but...
the rule is, the substance of the motion controls, and you said, hey, there was you didn't say condition precedent, but that's essentially what the
Correct. The case,
gravamen of the motion was.
the case can't proceed until we go through these steps which the parties bargained for. And it seems that in the Avatar case that this court enforced a non-binding arbitration provision. Now, we do have a dissent in there by Judge Alteburn, where Judge Alteburn says, I don't even think we have a jurisdiction to hear the appeal on this, because we can't appeal an order like Judge Stevens entered, saying, well, you moved off to non-binding arbitration. We have Judge Alteburn seeming to say that, I don't even think this court has jurisdiction on that issue. So, I mean, it's our position that I don't see how Mainstreet can prevail on this. There is no law in the state of Florida which would prevent the enforcement of language such as this. And as Judge Northcutt points out, it is really a conditioned precedent to filing a lawsuit.
Then what do you need the... Oh, I apologize.
I don't want to talk over you. You want to go first?
Please
Senior? So here's my question. Are you saying that under no set of facts, the trial court had discretion to deny your motion to compel non-binding arbitration? In other words, it seems to me there's an argument, there's efficacy issues, there's expense involved. If the trial court were to look at the big picture and say, I'm going to exercise my discretion and not enforce that clause, are you saying that's a legal impossibility as a matter of law? You could not do that. You must enforce this under every scenario.
And I disagree with Mr. Burns's position that there must be some finding of efficacy here. As I think as Judge Northcutt points out, these are fairly sophisticated business people. I don't know the court takes judicial notice of this, but this case has been in the newspapers.
Well, I mean, this was at the get-go.
And they want to have this private way to resolve it before a lawsuit is initiated. And that simply didn't happen. So it would be, yes, it would be my position that Judge Stevens has to enforce the language as the parties agreed.
Even though it creates a lot of procedural problems, apparently. You say it doesn't.
I say it doesn't. I use the example in my argument before Judge Stevens, which is Judge Levins on every case almost had a standard orders sending it all off to non-binding arbitration.
Assume for purposes of this question that we were to conclude that for purposes of the applicable statutory provisions, non-binding arbitration isn't arbitration. Would the trial judge have had the discretion to deny your motion if that was true, in kind of your view of the world?
And I would say no, because it's a fairly clear contract provision here, and the court.
Then what do you need the FAA for at all, right? I mean,
if the parties are agreeing to this particular procedure, which we contend goes under the, as the, it points out here that the agreement, it says the AAA in Hillsborough County, we go by their particular rules in the case. I mean, it does reference that, so.
How about the cost issue?
And so as I understand the procedure would be for, in this case, Mainstreet to initiate the proceeding. I don't really know what the amount of their claim is going to be. The cost is based on the amount of the claim. They're talking somewhere between $1 million and $5 million as the claim. And we contend it's their responsibility as the claimant to pay that. Now, to the extent that we are going to raise a counterclaim within that arbitration proceeding, we will then be required to pay for whatever the amount of that counterclaim is.
I mean, wouldn't we look to the AAA rules on non-binding arbitration to decide who's supposed to pay what? I mean, under the contract?
My contention, again, is that this should be borne by the party that is initiating
You're
it.
speaking of an equitably, but this is a contract. So
Correct.
we're not really in equity here.
Correct.
Correct.
So again, my contention is based on the case law that I've cited. There really isn't any case law that I have found which required on the non-binding arbitration when that was enforced to divide that. So it would be my position that it would be the responsibility of Mainstreet to pay for that. And that's all I have, unless the court has any specific questions.
We don't penalize people for not using our home.
Thank you.
Thank you, Mr. Johnson.
A couple of points. The first is we're making a slightly narrower argument than I believe has been discussed. We're not saying that non-binding arbitration in all forms is always unenforceable. We're saying that you need to look at this specific clause and what it does, and then hold that this clause is unenforceable.
assuming we agreed with you on the statutory matter, does the trial court nonetheless, as a part of whatever discretionary or equitable authority it has to stay or abate proceedings, could the trial court have made an order that says whether this is arbitration or not is irrelevant to me, I'm staying the action until you've complied with the contract?
Yes, and let me explain this because I think it's important. Once you conclude that it's not arbitration under the FAA or RFAC, then you're in a world where the procedural authority to do this would come from like Rule 1.800 and 1.820. My colleague said that there is no requirement that the judge make a finding that it's beneficial to the litigants. I'm just going to read directly from Rule 1.800. It says, if the judge determines the action to be of such a nature that arbitration could be of benefit to the litigants or the court, it may refer the case to arbitration, and that kind of arbitration could be non-binding. But that kind of arbitration is significantly different than
I guess I was asking a slightly different question, which is, listen, I think a trial court enjoys some inherent authority in the management of its docket to just say, you know, I am going to stay in action for various reasons. The most frequent way it comes up in my experience is, listen, you should stay this until we've had a motion to dismiss, heard and decided, say. Is there any reason why, just independent of maybe what the applicable texts say, a court does not have some equitable or discretionary authority to say, listen, I'm just going to abate proceedings until we've dealt with this issue?
Certainly does. But I think what would happen procedurally at that point is that we would file a petition for writ of mandamus, saying the judge needs to do his job. And he's not made the appropriate findings to refer this to non-binding arbitration. This is not arbitration under the FAA and RFAC, and trial courts are not allowed to just sit on their hands and do nothing. They actually have to have some sort of reason. So I think procedurally that's how this would be teed up if you were to hold that.
Could the judge say it would be a benefit to the parties to have this condition precedent issue wrapped up, so we'll send it to arbitration, rather than to have it lingering out there, which it still will be.
Theoretically, the judge, like in any other case, could make that finding. I think in this case, the judge can't make that finding, particularly in light of the findings he's already made that this is an expensive and silly appendage of litigation. It's just adding a layer.
I had an epiphany when I was in the shower and I've changed my mind. You could.
Of course, that's a possibility, but I'm saying that that's highly unlikely.
Judge Solario says that's my foresight.
Okay, could be. Right. There were just two other, or maybe it's just two other points that I wanted to make. The first is, you're talking about the motion to dismiss, and it could be construed to be condition precedent. I think I might agree with you if the motion was filed by a pro se litigant, because then you have to read it more liberally. But here it's filed by counsel, and it didn't use the words condition precedent, so that's not been litigated.
Yeah, but in the body of the motion, he's describing what is arguably one.
I think it's not on point enough to raise that ground, and if you were to rule that, you'd essentially be denying us of due process because we didn't have notice of what the argument was, and it's just not been litigated. The trial court even hasn't ruled on that particular question yet. The final issue is my colleague is saying that there's no Florida law on this. First of all, the FAA is federal common law, and that's what governs. And then the RFAC is, its own statutory authority. We're relying on the statutes and the procedural rules. It's essentially a plain language interpretation of these things, and that's why we believe it's not arbitration under either of those statutory schemes. So the relief that we're asking you for is either to reverse the order in its entirety, or vacate it and remand with instructions about what you think the appropriate payment is for the parties.
Thank you very much.
Thank you.
Thank you, Mr. Burns. You must have an incredible internal clock, because you hit 5 minutes right there.
I played basketball for a long time, so I got the shot clock.
That's what it is. Down to the waning seconds of the
Yeah.
argument. Thank you both very much. Interesting case.